Good afternoon, good morning, good evening, everyone, and thanks for joining us in this webinar today. Let's give just a couple of seconds more for other attendees to connect. But perhaps while that happens, greetings on behalf of IUCN World Commission on Environmental Law. My name is Fabiano de Andrade Correa. I am co-chair of the Climate Change Law Specialist Group, together with Professor Francesco Sindico, our speaker for today. As you know, we are coming to the end of a very momentous year in terms of climate change law. Not only the development of climate change law is increasing throughout the world, and climate change litigation is also becoming a very powerful tool used in different ways. But at the international level, we are going through three very significant processes that will, in our view, really contribute to the development of climate change law, whichever is the outcome of these processes. And sorry, these are the advisory opinions that are happening or have happened before international tribunals as we speak. Earlier this year, we had the rendering of the advisory opinion of the International Tribunal of the Law of the Sea. Currently, we are going through the advisory opinion proceedings of the International Court of Justice, which is really the focus of our webinar today. And there is also an advisory opinion pending before the Inter-American Court of Human Rights. IUCN, through WCEL and the Climate Change Law Specialist Group, has played quite an active role in all three advisory opinions, with the preparation and submission of contributions to the courts. And in particular, last week, IUCN participated, represented by Francesco Sindico, Cristina Voigt, and Gretel Aguilar at the ICJ, at the oral proceedings of this advisory opinion. So our aim with this webinar today really is to provide an update and really an in-depth and first-hand view on how the proceeding before the ICJ is going, what happened last week, and what can we expect moving forward with this advisory opinion. And no one better than our Francesco today, who was part of the team delivering IUCN's submission in the oral proceedings, to tell us a little bit more about that. So without further ado, I'll give the floor to Francesco, and we'll have space for questions later on. Thank you very much for joining us today for now.
Thank you very much, Fabiano, for the kind introduction. And I am delighted to see many participants in the webinar, some of which I recognize, some of which I will be delighted to be in touch afterwards as well. First of all, a huge apologies from Professor Dr. Cristina Voigt. She was our lead counsel. She's the chair of the World Commission on Environmental Law. But for personal reasons, she cannot attend this webinar. So I'm afraid you're stuck with me, and I will do my best to share with you some insights from our experience before the ICJ at the IUCN. I do have a deck of slides. I will be using it. And then afterwards, as Fabiano said, both of us, Fabiano and I, will be delighted to answer any questions and enter into a conversation with the participants to this webinar. So let me see if I can share the slides. And I just kindly ask Fabiano if you can see them.
Yeah, you're good. You're good now.
Great. But can you see them as a full screen? Yes, perfect. Okay, great. So the three that you see there, for those of you who do not know us, is, as I said, Professor Dr. Cristina Voigt on the left. On the right in front is Dr. Gretel Aguilar, the Director General of IUCN, and obviously behind is myself. The three of us were counsel at the ICJ last week. A fourth person called Edgardo Sobenes, an international lawyer in The Hague, also worked with us for the oral proceedings. But as I will soon say, there were many more people involved. Just to frame this case, and it's actually not a case, that's the whole point, for those of you who may not be working in international law on a day-to-day basis. This is an advisory opinion. It's not an adversarial case. So it's not a situation where you have one country allegedly claiming that another country has breached international law and suing, bringing that state to court, seeking some sort of redress. This is not what is happening here. This is an advisory opinion, which is when a specific authorized body of the United Nations, in this case the General Assembly, asks a or more legal questions to the International Court of Justice, seeking an answer, a clarification of points of international law. It's important to have that in mind because if we are in an adversarial case, in a bilateral case, the decision of the ICJ is binding, whilst if we are in a situation of an advisory opinion, the opinion is not legally binding. However, most people will say that it is very persuasive, it's morally persuasive, but it also carries a lot of legal weight. And we can discuss what we actually mean by that maybe later on. So these are the two questions that have been posed to the 15 judges of the International Court of Justice. We'll look at them in a bit more detail later on. But here what I want to highlight is that yes, we are before the highest judicial body of the world, as often the ICJ is referred to, but also we are in a heavily politicized environment. And what do I mean by that? These questions have been negotiated fiercely, just as a final COP decision outcome could be negotiated, just as the specific provisions of a treaty are negotiated. And partly the reason why these two questions, obviously that's your judgment, are so broad is because those negotiating them and those campaigning for them, those states that were sponsoring them, if you want, wanted to allow it to have as broad consensus as possible. And in fact, the General Assembly resolution that brings the questions to the court has been adopted by consensus, if I'm not mistaken. We need to say, and we need to acknowledge the amazing work of a group of students, now many more, who in 2010 dreamt about this, and this is the Pacific Islands students fighting climate change. And then, led by Vanuatu, they have over the past 5 years mobilized international society and a number of countries to really make their dream come true. And it was really refreshing, in my opinion, and quite moving on the last day to see them have the opportunity to actually speak before the judges and explain their frustration, their battle, their fight against climate change. So these are the two questions that have been asked. This is the journey that we have had at the IUCN, but also every other state, 96 of them, and international organizations. If I'm not mistaken, there were 12 of us. So the fact that IUCN was in the ICJ was not a given. This is very important to understand. A state, yes, a state, as long as they want to go before a court like the ICJ in advisory opinion, they have the right to do so. International organizations like IUCN have to request to participate, which we did back in March 2023. If I'm not mistaken, the request to the ICJ was in December 2022. We then had over a year to prepare our written statement, which was presented by Professor Dr. Christina Voigt in March 2024. Then a very important phase started, which I am very, very proud, if I have to say, of how IUCN dealt with it. Every single party, state or international organization, who provided a written statement had then the opportunity to comment on everybody else. And this was a huge endeavor, absolutely huge endeavor, where we, and you'll explain in just a few slides who the we is, we really mined and monitored and analyzed everybody else's submission and provided what we thought were useful comments to the 15 judges, to the court. That was in August 2024, and I had the pleasure to provide the court with these written comments together with Edgardo Sobenes. Obviously, last week the oral statements have concluded, 2 weeks of them, and whilst we all hoped that was the end of it, that we could finally go back at home and relax, the 4 judges decided to give us some more homework and provided us with 4 questions with a very long deadline of a week. IUCN is now involved in dealing with these questions, so our work is continuing this week. It is important to highlight, like Fabiano did, that this is not just one advisory opinion. There have been 3 advisory opinions: ITLOS, International Tribunal for the Law of the Sea, and the Inter-American Court of Human Rights. IUCN has been present in all 3. Professor Dr. Christina Voigt, chair of WCL, has led counsel for all 3 advisory opinions. And this is important because we have really tried to harmonize the messages that we have provided the 3 courts in order to consolidate the messages that I will now share with you in just a second. So, how did we do this at IUCN and who did it? IUCN is a huge organization. We made it very clear to the court, thanks to the words of Dr. Grethel Aguilar, our Director General. We have many, many sovereign states who are members of IUCN. We have many, many more members who are civil society. We have subnational actors. But then we have up to 7 commissions that are made of 14,000 members of these commissions. It's a huge, huge organization. The one part of this mosaic of IUCN that was tasked to lead on all 3 advisory opinions was the World Commission on Environmental Law. Within the World Commission on Environmental Law, a core group was developed, established. And on the slide, you have the names of those who very generously and kindly agreed to join the core group. But it was much more than just that. We then had a wider advisory group that provided feedback and comments. We're talking a lot of people here, mostly from the climate change specialist group, but also the chairs of the other specialist groups contributed. We also had feedback from the steering group members of the World Commission on Environmental Law. And it goes without saying that we had comments and feedback from the IUCN Secretariat as well. And here you have the amazing members of the core group, of which Fabiano is one. And I really have to thank all of them, one by one, for the time they spent with us, the numerous meetings, crazy hours, and we couldn't really have done it without them. So a huge thanks, I know, also on behalf of Professor Dr. Christina Voigt and Dr. Grethel Aguilar for their amazing work. Now, I move to the part of the webinar where I'd like to share with you a little bit more about what we actually said before the ICJ. Now, all of this is now available. It wasn't so until very recently. We had to be very careful how we shared our information because the court made it very clear, this is not strange, it's how it operates, that all the written submissions and comments had to be confidential until the opening of the oral proceedings. But now all the documents I mentioned before, the written statement, our written comments, our oral statements, both the verbatims, the word by word, and the videos are all available on the ICJ website. So you will find all of this information there. But let me start with the first question. So the first question was, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? So really, in a nutshell, what are the obligations of states to protect the climate system and other parts of the environment? I must say, and let me be clear here when I speak about my own impressions of what I've seen at the ICJ, I'm talking with my personal capacity, definitely not like IUCN. I feel that, not surprisingly to some extent, but the countries were very much divided in two camps. You had a number of countries that were arguing in relation, especially to this first question, that really what the court should focus on is only the Paris Agreement. And that within it, states have a lot of discretion on what they can do in order to protect the climate system. They were arguing, some explicitly, some maybe not so much, but the end result was the same, on the application of the lex specialis, Latin word to say that the more specific rule will derogate the more general rule. On the other hand, you had, probably in terms of number, more countries and organizations that were saying that no, there's not just the Paris Agreement. You also have, you can find obligations of states also elsewhere. In specific, in customary international law and in human rights and other environmental treaties. One thing to highlight is that for many states that presented this position, they did start with a frustration. And this clearly comes from the campaign as well. There's a frustration that international politics, if you want to call it like that, international law, and obviously, because we're talking about climate change that refer to the Paris Agreement, is not working. And it did seem that they were looking at ways of finding other avenues of international law that, in their opinion, could work better than the Paris Agreement. But overall, most of them, if not all of them, did not discard the Paris Agreement at all. So I think there are two things to say here before I move to the next slide. The first is that I haven't heard one intervention, one state arguing that climate change is not happening, for example, that there's just no doubt whatsoever. And to some extent, obviously, there was not one state that did not say that the Paris Agreement is not relevant. It just, the divergence was on how relevant is it and what role it should have. So where does IUCN stand? I feel that IUCN stands very much, to some extent, in the middle, but very much advancing an integrated position whereby we believe that the Paris Agreement is principle and very important in all this question, but that you also have state obligations in human rights treaties and other environmental treaties. I'll get to that in just a second, and also in customary international law. There's a key paragraph, which I will read with you here in our oral statement, which really brings our position all together. And it says, every state has the obligation under international law to do its utmost to reduce greenhouse gas emissions, aligned with holding warming to 1.5 degrees, to limit any overshoot as much as possible, and to reverse it. The standard of conduct is of objective, stringent due diligence, and varies according to states' evolving responsibilities and capabilities. This obligation stems from parallel, complementary, and cumulative international legal sources. So I just want to highlight a number of things here. The stringent due diligence nature of this obligation. This very much is aligned with what we also have seen already released, the advisory opinion of the International Tribunal of the Law of the Sea that talks about stringent due diligence, not just any due diligence. This is about stringent due diligence. And as I will say in just a second, we emphasize a number of what we call international standards present in the Paris Agreement that inform this overall answer to question one, that is the 1.5 degrees and the emission pathway, which I'll just mention. And importantly, as I just said, this obligation is not just in the Paris Agreement, it's elsewhere as well. Let me take you to these normative international standards. I don't think there were too many other parties. There were some, but not too many other parties that actually developed a sophisticated argument, as I believe to some extent we did, when it comes to these normative international standards. And the point we're making, as you see in our point there, is that they do have legal implications. Which are these international standards I'm mentioning? You see them in the bullet points. It's about holding temperature increases to well below 2 degrees and to pursue efforts to limit the increase to 1.5 degrees. And to the IPCC and COP28 decision, by consensus adopted decision, emission reduction pathway and timelines for holding warming to 1.5 degrees. Both of them you obviously find in the Paris Agreement. What these legal standards, normative international standards do is that they inform state obligations contained in the agreement and those in other treaties and in customary international law. So this is the importance of these standards, because they help shape the answer to question 1. One thing that we highlighted very strongly, and again, let me take you back to the 2 camps. One camp says the Paris Agreement is everything and it gives us all the answer. Another camp says Paris Agreement, we're frustrated with it and it's useless. We highlighted that in order to develop an in-depth answer to question 1, we need to take the Paris Agreement seriously, as we said. And it is important that the machinery of the Paris Agreement is fully understood, the progression of NDCs, and these international standards that I just mentioned. But we were very, very adamant to make it clear to the judges that the Paris Agreement is not like specialis, absolutely, but it needs to be fully understood, and it does inform in a positive way other obligations, which are to be found in UNCLOS, as we have also seen in the International Tribunal for the Law of the Sea advisory opinion, in human rights treaties, but also others which we did not have time to deal with in the oral statements, but you can find in our written statements. And this would include, for example, even in the Convention on Biological Diversity and its implementation through a number of provisions therein and successive COP decisions. Customary international law was a big thing for many, many states involved in these advisory opinion. I wouldn't say I was surprised, but I do think that the emphasis that many countries put on customary international law, to the extent of other aspects, and especially the Paris Agreement in some cases, was very clear, very clear. Here, our position is that customary international law does apply to the protection of the climate system, and that even here, in the relation to the obligation to prevent significant transboundary harm to the environment or areas beyond national jurisdiction, states have to operate with a stringent due diligence. So very similar to what we said before, even here, it's not just any due diligence, it's stringent due diligence. That obviously has some parameters that we can go into more details. And as you see in our submission, this requires every state to deploy adequate means, exercise best possible efforts, and do its utmost, so very similar words as before, to reduce its greenhouse gas emissions aligned with 1.5 degrees. One thing that is important to highlight, yes, International Court of Justice, yes, advisory opinions or advisory or state versus state, but we all know that a lot of the emissions come from non-state actors, especially private actors. And we wanted to make it clear that in the context of due diligence within a state's territorial boundaries or under jurisdiction, this, meaning the customary international law, also includes regulating the conduct of private actors by putting in place adequate laws and by enforcing them with necessary vigilance. And this, I think, is a very important part, which hopefully will be picked up also by the court. So this is what I had said about the first question. Before I move to the second question, especially for those maybe in the room who are not lawyers and who may not have heard too much about customary international law, the importance for many states and in general to emphasize the customary international law nature of an obligation is that if all the state obligations are only to be found in the Paris Agreement or any other treaty, if a state decides to leave that agreement, then that obligation will not apply to that state anymore. However, if the court, if there is consensus that a specific state obligation amounts to customary international law, then that obligation will apply to all states, whether they are party or not to the Paris Agreement. So any country that is a party to a treaty, that leaves that treaty, if an obligation, even if it's reflected in that treaty, is also customary international law, will still be bound by it. And that is very important to understand because it has huge potential practical implications. I won't read out loud all the second question, it's quite long, but this is really about legal consequences if actions and omissions of state lead to significant harm to the climate system. And this is about liability. This is about what happens if you breach a state obligation identified in the first question. I won't go into the political negotiations to bring this question, but there were plenty of states here that again divided themselves into camps. And I'll try to share what those camps are. And they are similar. Well, those who were in the first camp follow in the second camp, as you can see here. So the first group of states were saying, guys, why are we even here talking about this? State responsibility does not apply here. And by the way, causation cannot be proved. These are the same states, almost always, that said that let's just focus on the Paris Agreement and there's nothing else. They were saying it follows from the lex specialis, even in terms of state responsibility or legal consequences, that you don't need to see anywhere else. Just focus on the special regime. The other camp, on the other extreme, you have a lot of states that are saying, this second question is very important to me because I am suffering damages today, yesterday, today, and even more tomorrow. And I want to know what happens if the state obligations that I feel are present in international law lead their breach or their omissions leads to more harm to my territory, to my identity in some cases, and so forth. And they say, because we have said that state obligations are found also in customary international law and in other treaties, we cannot just look at the Paris Agreement or just specific treaty. We need to look at general rules of international law. And these are the rules on state responsibility. And they will say, and I'll explain what IUCN says in just a second, that they do apply. And that because they do apply, you can then identify specific legal consequences. And some of them went as far as saying that this idea that it's complicated to identify the action of a state and create a causal link and attribution to a specific damage, a lot of these states were arguing that may have been the case 10 years ago, but science and research has evolved, and now we can do that. These are the same countries that were saying that Paris Agreement is not working, they're frustrated, and we have to focus more on customary international law and human rights treaties, and so forth. Where does IUCN stand in all of this? This was the part that I had the pleasure and the honor to present before the court, the last part of our pleading. And the 3 points I want to make are the following. IUCN agrees with the second camp that customary rules on state responsibility do apply. They do apply. They are the relevant legal framework. The second thing, however, we do say that exactly how they apply, let's say, the exact content of it needs to be developed, needs to be understood in the context of a specific case. In general, in abstracto, it's very difficult Whether counterproductive or not is another issue, but it's very difficult to come up with concrete examples of what the consequence would be. However, and the however is very important here, because IUCN does submit here that if in the future such a case does happen, if it were to arise, and if an international wrongful actor were to be established, which means causation, attribution, then we submit as IUCN that certain consequences will arise for the responsible state. And again, for those of you in the room who may not be acquainted too much with international law and state responsibility, there are three key consequences. One are cessation of the wrongful act, non-repetition, cessation and non-repetition, full reparation, which means money, which means reparation, compensation, where possible, and satisfaction, which is a slightly different thing. Interestingly, some states went quite in depth in developing their understanding of why causation can be found, and went in quite some depth in explaining details of what kind of reparation, for example, they would want. One that for me stood out quite strongly, which I thought was really interesting, was debt relief. For example, a lot of small island developing states and least developed countries were saying, we are in two crises here. We have the climate crisis, but we also have our debt crisis. We cannot even think of how to adapt to climate change because we have to pay so high interest on our debt that we are just in shackles everywhere. So in a way, they were saying, let's start by eliminating the debt or renegotiating the debt as a legal consequence to the obligations that have been breached and that are causing harm to our territory or even our identity. But again, that's not IUCN saying it. That were some other parts in the second camp that I just mentioned. I'm almost there, and then we can have a discussion with Fabiano and with participants. Because of such a broad nature of the two questions, there was food for thought for everyone in the 2 weeks of the court. Literally, we heard so many things. One that did come out very strongly was the principle of common but differentiated responsibilities and respective capabilities. Again, you could almost see two camps there. You would have a camp that was focusing very much on historical emissions and on underpinning the answer to question 1 and 2 on a historical approach to CBDR, and other countries that were saying, wait a second, the world has changed. Let's have a dynamic interpretation of CBDR-RC. And some went as far as saying the polluter pay principle today in 2024 should guide answers to question 1 and 2, which I felt it was just 1 or 2 countries, but I felt there were probably more countries that were thinking that. A lot of small island developing states made very compelling points about self-determination, of survival of nations, statehood, and keeping maritime baselines, whatever happens to their coastline. The extent to which they are fully integrated in as an answer to question 1, that's maybe to be debated, but there were very powerful statements. And there were a lot of examples coming from all over the world about the obvious links between climate change and nature and the negative impacts on nature, be it terrestrial biodiversity, marine biodiversity, flora, fauna, that is coming from the current emissions and the current level of climate change. The last thing I will share with you is, as I said, we were all hoping last Friday to sit back and relax. And can I say it? After I spoke, literally after I spoke, I sat down and the 4 judges decided, no, I want to speak. Now, again, for those of you who do not work in ICJ matters every day, the fact that after 96 half-an-hour statements of states and 12 half-an-hour statements of international organizations, and considering you have 15 judges, you only have 4 questions, may seem very little. But actually, just try and Google 4 questions ICJ. This is probably what was most picked up by even media and by important press releases and so forth. Because the fact that judges ask a question one could interpret points in a specific direction. Whether that is true or not, we can discuss. So you have the questions there. I won't read them out loud, but one is focused very much on fossil fuels, on countries that still have fossil fuels, what they should not do. Second one was probably more technical, if you want, about the procedural nature of Article 4 and so forth. And last but not least, two questions. The first one about expanding on the right to clean, healthy, sustainable environment, so human rights question. And the last one from the Australian judge was about very much question 2, I would say, but linked to state practice, to comments and remarks that states had made when becoming parties to the UNFCCC and Paris Agreement. And I do remember, I will remember, I missed the last moments in Paris, but, you know, for my sins, I did see it afterwards, recorded. And I remember at least one country that in asking for the floor said very clearly that whatever the Paris Agreement says, and whatever paragraph 52, if I'm not mistaken, of the COP decision accompanying Paris Agreement, they were adamant in their statement that general international law still applied. And this 10 years later, almost 10 years later, is almost the same kind of question that the Australian judge has made, at least in my interpretation. So it will be very interesting to see how we at IUCN develop our answers, but everybody else, and the weight that these answers will have on the actual opinion of the court. I will stop there, Fabiano. I will stop sharing, and I'm happy to take any questions, but also very happy for you to join me in answering those questions. I'm trying to stop sharing. There we are.
Thank you very much, Francesco, for guiding us through understanding better what happened and IUCN's participation. I think this is truly a fascinating moment. We are witnessing really a moment of development and clarification of international law in this area that was long overdue. So we have now about 20 minutes for questions and interaction. You can either, I believe, open your microphone and pose a question online, or you can also use the Q&A function in the toolbar below this window here. As I don't see any open questions at the moment, I actually would like, Francesco, if you could elaborate a little bit more on perhaps a few comments of parties that delivered oral submissions on the obligations of the Paris Agreement and how they viewed, you know, you already pointed out that the world is pretty much divided in two camps. But were, for instance, countries that said that mostly Paris is all there is, and they have broad discretion, that Paris is mostly procedural, the parties have free determination to do whatever they want with their NDCs, the legal significance of NDCs at international level, did anybody go into that? And then on the other hand, the other camp, what were the main arguments? And if there was anything else in between, I'd be very curious to know.
My sense was, very keen to also hear Sandeep afterwards. I mean, my sense was, and in a way, I think one of the 4 questions of the judges is precisely about that. And I think probably the judges were a bit confused at the end because of these two camps, because of the fact that you would have countries that would say the latest embodiment of state consensus is the Paris Agreement when it comes to dealing with climate change. And it was a delicate balance and political process, and so forth. But that's what states agreed to in 2015. And some would then take it more on the procedural side, let's say, and say, and now we have that, and we have this obligation to submit an NDC, so forth and so forth. what I don't think, we did this at IUCN, I have to say, but not many parts explained it. A lot of people did not explain to the court the fact that the Paris Agreement is an engine that continues, and it's an engine that moves obviously too slowly from a climate crisis perspective, but considering how it works every 5 years, it ratchets up its highest ambition and all that kind of things. That I don't think was explained too clearly. And even where it was, again, I think the court needs to understand that this ratcheting it up is based on these international normative standards, which I mentioned before. I also think one thing that, and this doesn't minimize any frustration of states or people, I get it. But everybody forgets to some extent where the world was going before the Paris Agreement in terms of emissions. And actually, despite the fact, and we all agree, we know that the Paris Agreement has not curbed it down to 1.5 degrees today, the world is doing slightly better than what it would have done without the Paris Agreement, according to some studies. And I think this was not very clear, let's say. But keen to get also other questions and maybe jump into that.
So, Sandeep, I see you have your hand up. Can you open your microphone and speak? Otherwise, you can post your question in the Q&A section.
I think
Hello.
maybe I use, oh, there you are.
Hi, can you hear me?
Yes, we can, Sandeep.
Yes.
Okay, great. I'm not sure who the audience is, but just for the sake of introduction, I'll just say that, I'm Sandeep Sengupta. I'm the Global Policy Lead for Climate Change at IUCN, based at the IUCN headquarters in Gland, Switzerland. So I'm part of the IUCN Secretariat. So at the outset, Francesco, I just wanted to really, really congratulate you, Christina, Gretel, the World Commission on, Environmental Law for this, for this amazing leadership role that, you have collectively played in positioning IUCN so well in this, in this sort of historic process that we now have. I've been following climate negotiations, climate politics for an awfully long time now, within IUCN for the last 20 years, for the last 10 years, but previously in other capacities itself. And the very fact that the ICJ was asked to render an advisory opinion on this topic, and as you rightly said, Francesco, it wasn't a given that IUCN would be invited to participate in the proceedings. So this is a really historical moment, not only for the climate process entering into this judicial realm, but indeed for IUCN playing such an important role. And so I really just wanted to start off by, by congratulating you and by thanking you for positioning IUCN in this space. I had a couple of questions. One is, of course, you said that, part of the rationale of all of this is that, okay, taking climate action and maintaining a level of stringency, it, an advisory opinion can help it become part of customary international law. The one question that I had in mind is, the enforceability of customary international law. So if something becomes customary international law, what are the implications of that? And what is the enforcement mechanism, if any, to ensure that, such law gets actually implemented and enforced on the ground? And the second question that I had is, you just mentioned that all of the written submissions and indeed the opinions that the various parties had on each other's submissions have now been public. So I was curious to know whether, what were the reactions of other parties, international organizations on the IUCN submission itself? Because I thought it was terrific. It would be interesting to see what the other comments or views, if any, were. Thank you.
Thank you, Sandeep, for the kind words. Actually, starting with that, I mean, I do think, and I was thinking of this when the international organizations who were authorized to speak before the court started, and it just dawned on me that most of them, for obvious reasons to some extent, were very regional. You had organizations that focused on the Pacific, or Pacific, Africa, and the Caribbean, the European Union. But except maybe for the World Health Organization, which had a, as you would imagine, a very health focus, I'd say we were probably the only global international organization that actually engaged very thoroughly with the two legal questions. And obviously we had to make some strategic decisions. There may be some things that we didn't say, especially at the oral statement, that others would have expected us to say. But I do think, and I do hope, that the judges may have appreciated the fact that our membership is so global and that we did address the two questions. Now, going to the enforcement of customer international law. So what happens there is that this is my thinking, not IUCN's, obviously. It becomes highly political. And what I mean by that is that let's assume that the court clarifies that some of the things that we're saying do amount to customer international law. Potentially what would happen then is that a state would then say, well, if that is customer international law and I believe that another state is violating it, I will go before a tribunal and try to argue the customer international law route. If it does that, and your question is very valid, is, okay, let's even assume that that tribunal agrees and that customer international law has been breached, then the question 2 becomes relevant, because then really you're going there to get some consequences to that action. So then the question is, okay, let's assume that what you're asking as a redress is for that country to stop acting in an unlawful way. For example, you have been incredibly successful to argue that subsidizing fossil fuels is illegal under customer international law, and you want that country to stop. But obviously that country will stop subsidizing fossil fuels only if it has a political will to stop it. There will not be any enforcement mechanism. There's not be an international police that goes and stops that country to do subsidize fossil fuels. Or say that we're talking more in the climate finance area, you want to go to court, use the customer international law card, and you ask for compensation. But then obviously it has to be that specific country that has been considered to have violated customer international law to agree to pay back or whatever. The one thing I would say is that no country, whoever it is, likes to be named before an international court as violating the law. No country. And every single country will do whatever it can through legal means and everything, hiring, developing their own capacity of legal profession, whatever, to go before a court so that that does not happen. But the truth is, Sandeep, that we wouldn't be in such a different environment than what you experience when you go to political negotiations, where at the end of the day it becomes a political decision. Which is a bit my slight concern for those who are putting so much emphasis and so much reliance on customer international law, because especially in the short term, the capacity of getting your climate objectives through customer international also depends on political will of those countries who you are arguing against. So I hope that that helps, Sandeep, a little bit.
Very much. Thank you.
So we still have about 10 minutes. Anyone else would have any question, any request for more information on any other points mentioned by Francesco? I would also be curious to hear a little bit more about the types of reparations that were mentioned, as you pointed out, Francesco. You gave an example of debt relief, but any other like major blocks of reparation instances that were raised?
I already mentioned the debt relief, which I found really interesting. Climate finance was on everybody's lips, those who obviously were on one camp There was not only frustration, but anger to the number of Baku. That was very clear. And actually, it was interesting to see because on the other camp, there were countries highlighting Baku as a success. And I think that almost you could feel the tension in the room. You could literally almost feel the tension in the room. But yes, loss and damage, climate finance, debt relief. For the most vulnerable countries, especially low-lying small islands, also the very strong request that in the worst possible scenario, that statehood is preserved. And that was very, very strong and very, moving if you want. But it is a reality. In some of these countries, that is literally what may unfortunately, very unfortunately happen. So yeah, I mean, yes,
what could that look like in the case, for instance, of physical disappearance of a state? Was any argument to that point that continuation of statehood in some other form?
Yes, but there wasn't so much about the usual climate refugees kind of discourse. That wasn't touched too much. But there was this idea that, for example, the natural resources under the sea, according to today's maritime boundaries, should stay sovereign for the state, even if that state doesn't have any territory, which is a big thing to say. And there's legal disciplines. The IUCN is working on sea level rise and everything. So there were some of these points were brought in. The real question, however, is, do they really answer question one? Obligations to protect the climate system. Is it really related to that obligation to respect statehood? One could say yes, but you do need to do a little bit of elaboration of the question itself, which is another thing. One thing I did not mention, I heard at least one country that actually suggested to the court, you know what, this question is a bit too broad, a bit too vague. Why don't you reinterpret the question? Which again is a bit of a misnomer for anybody working in domestic law. I mean, imagine going to a domestic judge and saying, by the way, why don't you change what I am being accused of, or stuff like that. But it wouldn't be the first time. It wouldn't be the first time that an advisory opinion, the ICJ actually, I wouldn't go as far as saying reinterpreting, but does fine-tune the question a wee bit, let's say. So we'll see whether that may or may not happen.
Okay, well, seeing that there are no other questions, I would suggest we just use the final minutes we have available. Francesco, if you could give some final words on what happens next.
Yeah.
These 4 questions are going to be answered, and the expectation is that all parties will provide answers. And then what's next?
So I believe most will pick and choose the questions, let's say. The modus operandi usually is that if you have answered these questions in your written statement or in your comments, you shouldn't really be sending another answer. But if you feel that you haven't elaborated enough on these questions, then you should. And the court will probably receive a lot of answers. What happens afterwards is obviously all speculative, but my hope is that this ends up strengthening climate multilateralism and climate action. I do see that clearly there is, borne by that frustration that I mentioned, especially from small island developing states and least developed countries. This may pave the way for future litigation or future threat of litigation, be it before in front of the ICJ or other international tribunals. But I would hope that this threat of litigation is a way to boost more ambition in domestic climate change and international climate change when it comes, for example, to the next COP, the intersessionals, and so forth. Most likely, when COP 30 in Belen happens, the ICJ will have released its opinion, although we don't know when it will be, but I would hope so. And there, I think the relationship, and I think it's going to be exciting for people like Sandeep as well, to see how these two processes talk to each other. Until now, it was the law talking about Paris and talking about Baku, the frustration, or how it works, or how it's. starting in Belém, you'll see the negotiators picking and choosing elements of the ICJ advisory opinion in the way that it works for them. And it will be really interesting to have this translation of the ICJ advisory opinion to non-lawyers, both negotiators and not, to see what they can use, again, hopefully to strengthen multilateral climate action and make it go faster and better and everything. So that's what I hope. The last thing I would say is that for any of you who have not seen the 2 weeks, obviously I don't expect or would want you to spend the Christmas holidays or whatever holidays you may or may not have looking at them. But I do have to say that it was really fascinating, in my opinion, to see so many countries for the first time in their history before the International Court of Justice do so with their own capacity. And by that, I mean that a lot of counsel, not all of them, but a lot of counsel was from that specific country or trained in that specific country and was there for the first time and really brought a completely different flair, a completely different flavor to what we are used to listening and hearing before the International Court of Justice. If anything, this advisory opinion, in my opinion, has achieved this. A much more plural, a much more diverse set of counsel, of colleagues, of countries before the highest judicial body of the world. I will stop with that.
And just a final word. So between the answering of these 4 final questions, is there any other step before the submission of the actual advisory opinion by the judges?
Not that I'm aware of. Some of you may know that they have met with members of the Intergovernmental Panel on Climate Change literally the week before they started the oral proceedings. A lot of eyebrows were raised, like, what, now? Who? Who was there? Where are the minutes? I heard some interesting comments by saying this was the less of the evil, or whatever you say in English, because by not being public, apparently, the judges were freer to ask questions and actually interact with the scientists. Whether that's the case or not, obviously, we will never know. But as far as I'm aware, I don't think there's anything procedurally between now and the actual opinion being released.
Okay, well, thank you very much, Francesco, for devoting this hour to really update us on so many details. I think there is now a lot of expectation, obviously, on what will actually happen. But this has given us a lot of food for thought and insights into what to expect. So with that, I will thank also all the participants that joined us today. This will also be recorded and I imagine be made available online afterwards, so that more people can also follow. But for now, thank you very much, everyone, and indeed, Francesco, and a good rest of your days wherever you are.
Thank you very much to everybody. Thanks, Fabiano, for sharing. Bye-bye.